Pet Supplies Plus offers you all the convenient ways to get your next order easy and fast. Just go to PetSuppliesPlus.com to get
Salute. They still at recess. So we just waiting. Oh yeah, most definitely. Most definitely. It's all shit, it's already crazier than America. Most definitely is. I'm just sick of it, for real, for real. They gotta I'm just waiting for them to get to the meat and potatoes because man, they so boring. Even though, you know what I'm saying? Hey, nah, I gotta work both channels. You know what I'm saying? I gotta work both channels. But the third case, and I know it don't supposed to be exciting. It ain't like it's supposed to be like a field trip, but you know, it's just too boring for me, for real, for real. I be trying, but I get bored quick. So we still in recess, man. It been longer than 15 minutes too, man. Judge, hey, listen, and I ain't gonna lie, the judge, he tired of this shit though. It's like just how we feel, Judge feel the same way because he been going off on there like a motherfucker. Let me pull it up. He been going off on there. He been a lot of frustration in this case, and they just picked the jury. Like it's just started. Give me a sec. And if y'all ain't subscribed to this channel, make sure y'all subscribe to this channel. Let's see, Judge Greenlight rap lyrics. Yeah, so for the people haven't seen it yet, the judge did approve for some of the rap lyrics to be used in court. So I didn't know they can use cases people already been convicted on in the Rico case. Oh yeah, for facts, for sure, for sure. That's how. That's how the dude with the that shot up Lil Wayne bus, Thug homie. He already did his time for it. You know what I'm saying? But he got out, and they went and got him again because they were saying that him shooting up Wayne bus was incorporated into doing it for the game, doing it for YSL. So that's why they when they got him again for the same shit because they were saying he did it on the strength of the game. For sure, for sure. Appreciate you pulling up, man. Just stop self snitching. Yeah, for sure. But they ain't gonna, man. That's the art of music, man. They done switched the goalposts. Hold on. They done switched the goalposts, man. They rather tell you how real they is and show you how real they is. We just gonna watch this real quick until the trial start back. This the judge allowing hold on, let me see. I heard something. Trial probably finna start back in a minute cause I heard them moving around. But this right here, the judge allowing rap lyrics to be used in the case.
Let me go ahead and like I said, when we recessed last night, courts had an opportunity to ponder the issues that were presented yesterday in terms of the admission of lyrics or the exclusion thereof. So to that extent, the court has considered the state's motion in limine to admit evidence of lyrics, the state's supplemental motion in limine to admit evidence of lyrics at trial, the state's amended particularized motion in limine to admit evidence of lyrics at trial, the opposition to the state's second supplemental, and motion in limine to admit evidence of lyrics at trial filed by and on behalf of Mr. Kendrick and argued by Mr. Weinstein, as well as Jeffrey Williams' motion in limine number 2, 1, and 2 to motion to strike, as well as Mr. Shart's oral motion, and the court will also consider it for any other lyrics that may be sought to be admissible in the trial of this matter. Specifically, I have considered the arguments of the state as well as the arguments of the defense. I'll kind of go through those in just a second. The state has argued that this particular gang lyrics or evidence is admissible for several reasons. One, to show actus reus or mens rea, or other offenses under 16-14-4, 16-15-4, or 24-8-801D2 alpha, 28-8-801D2 bravo, 24-8-801D2 echo, and 24-8-804 B3, specifically, as well as 16-15-3, 16-15-9 for those particular relevant purposes. The court is well aware that there are several gatekeeping functions that the court must perform in determining logical relevance under 401, presumptive admissibility under 402, and legal relevance under 403. The defense has argued that use of these particular, the admission and use of lyrics, poetry, or artistry against Mr. Williams or any of the other named defendants as appropriate in this upcoming trial would be a constitutional violation, abuse of discretion, too prejudicial and unconstitutional based on the provisions of the U.S. Constitution as well as the Georgia Constitution, and that moreover, using these lyrics, poetry, artistry, speech against Mr. Williams and others would be racist and discriminatory because the jury would be poisoned, prejudiced by these lyrics, poetry, artistry, speech as the same as unlawful character assassination. The defense has asked me to exclude or these particular lyrics, poetry, words, speech, artistry from the indictment and exclusion from testimony and evidence pursuant to 24-4-401 24-4-402, 25-4-403, and 24-4-404A, as well as the constitutional provisions as set forth in the Georgia and U.S. constitutions. Mr. Williams, as well as others, have asked this court to further suppress any video, photographs, posts, or images that deal with these particular lyrics, words, speech, poetry, artistry, to be excluded from trial as well in total, and that these videos are protected speech as articulated by the same aforementioned provisions of the Georgia as well as U.S. Constitution.
Why are you not investing in tax liens? No, seriously. Why are you not investing into one of the most incredible?
And as I mentioned, these arguments, the court's going to apply as to all parties, not just the ones that argued yesterday, Mr. Steele, Mr. Sharp, and Mr. Weinstein. The court also, in considering this particular ruling, considered under the provisions of 24-1-104, which is the conditional admissibility or screening determination that this court may make. And I'll cite from our code, preliminary questions concerning the qualifications of a person to be a witness, the existence of a privilege, or the admissibility of evidence shall be determined by the court subject to the revisions of the subsection B of this, and that's on relevancy, depends on the fulfillment of a condition of fact. Court shall admit it upon or subject to the introduction of evidence sufficient to support a finding for fulfillment of the condition. So if I have to look at A before I can get to B, but
What it is his lyrics can't be used against him, meaning he can't be charged for it, but they can use the lyrics in the songs to paint a picture of his image or paint a picture to a better understanding of painting a narrative of how they felt something happened. So, like, for instance, in the example, Wildfin Lucci, his mama house got shot up, right? Months later, Thug made a song and said, basically not word for word, but basically saying, they had something to do with somebody mama house getting shot up. So they can't charge Thug for that, but they can use them lyrics to say, look, Lucci mama house got shot up. And Thug in the song saying your mama house got shot up, insinuating that they did it. So technically, 9 times out of 10, they probably did it. That's why he rapped about it. Like, they could use it to paint those kind of narrative, but they can't use it and say, oh, he's guilty because he said it. Nah. But it is kind of tomato situation. Like, you could use the lyrics to paint a persona about somebody, but that can cause them to be guilty. But you can't say, oh, they guilty because they said it. So it's like a tomato thing to me.
it also mentions that subject to the revisions of subsection B of this code section, in making this determination, the court shall not be bound by the rules of evidence, except those as respect to privileges. Preliminary questions shall be resolved by preponderance of the evidence standard. and then B covers the relevancy of a condition of fact and so in this particular circumstance, the court's just making a preliminary admissibility determination. Of course, anything that the court may rule upon at this point in time will be subject to a complete foundation being met and may be subject to other additional objections. But the court has considered, in terms of 104, states 1 through 20, as well as defendants 1 through 4. Mr. Weinstein, thank you. We got the PowerPoint you presented yesterday. We also have D2, D3, which is, I believe, the drive, and D4 presented by Mr. Steele, and D4, which was the chart that Mr. Steele circulated for the courts and parties' consideration. So I've considered that universe of conditionally admissible evidence for my consideration on the ruling, on this particular ruling. The court has also further considered in making this ruling the commonality of specific lyrics as they relate to the issues of mens rea and actus reus. Also, the court has also considered that depending upon.
Here's one.
And I agree with that. I agree with that. I actually had a conversation with my son about that. I was telling him that, you know what I'm saying, if it was any other people, any other culture, their music wouldn't be used. And my son, he's only 16, right? And my son was like, I get that, but look at their personality and you know, their persona. So I thought about it. Okay, they more likely to use our skin tone people music other than the other, because Thug is presenting himself to be the person he actually is on the music. You know what I'm saying? He's representing himself to be this gang banger and this supposed to be whoever, you know what I'm saying, in the music. And that's his everyday lifestyle. Even though it's just lyrics, in his everyday lifestyle, he's portraying to be what he is in the lyrics. And then you have these country singers and these rock stars that rap about crazy stuff. But if you look at their lifestyle is totally different from the music. So I think that's why they use more of our music than they will use it against another culture, because we actually try to portray the music. We actually have the image of the music. You know what I'm saying? Like Thug say he a slime. Thug say he a blood member. We could see that he's on camera and in videos throwing blood signs, hanging with blood members. You know what I'm saying? He say, you know, Wildfire and Lucci Mama House got shot up, you know what I'm saying? And then he put it in his music. Well, we do, and we can find proof that Wildfire, I often say YNW Metal, but Wildfire and Lucci Mama House got shot up. We can find proof. And then when you go back to country singers and stuff like that, and like your boy, I Shot the Sheriff, there's no proof that he shot the sheriff. You know what I'm saying? So I think that's why it's more likely for them to use our music than country and all this other stuff, because the shit we talking about, they actually is trying to live this shit. And the country people is just talking. That's the difference. See, that's totally different. See, back in the day, motherfuckers was just talking. Basically, they were just capping their rap. They was lying about what they were doing. Now these guys is actually rapping about what they're doing. So that's why we can kind of try to compare the lyrics with the lifestyle. Even though we can't charge it against them, they can't be, but these guys is actually rapping about what they're doing.
One thing you need to do before buying anything online. Don't spend another dime on Amazon until you watch this first. Watch.
Proof presented in this case, and that YSL, it's and testimony that may be relevant of the gang's organization and or strength would be relevant. The court has also considered that these particular statements are being offered to show the elements of the offenses and not the threat or conduct is not being prosecuted, but these particular lyrics can be associated with different things that the court mentioned that the state has proffered in States 19. As it pertains to the First Amendment assertions raised by Mr. Steele and Mr. Weinstein and Mr. Sharp under the First Amendment, the court has in fact considered Carpenter among other cases that were cited for the court's consideration yesterday, and that these lyrics, that rap lyrics are relevant, and they must, that the court must conduct a 403 balancing test, which it shall. In terms of First Amendment analysis that Mr. Steele suggested I needed to conduct,
Dre, that's actually a good idea. Paradox said, I get it. They put on a persona that they actually are living. They get all the money because folks behind them know that they won't keep it and are not really creating a generation of wealth.
Divisions 1, 2, and 3 this can be distinguished because the Superior Court erred on ruling on the issue of sovereign immunity, and the applicable section that Kuhn was relying upon is 1611-131 Delta, which is not the applicable statute that is involved, or subsection involved in this particular matter. However,
Free R. Kelly. Hey, Miami boy,
and in Division
you got one strike, gang. You got one motherfucking strike.
Like some
Please don't get too much.
analysis on when interpreting a Georgia statute and a federal court decision construing a federal statute rule have persuasive value only to the extent that the language and content of the Georgia statute at issue are materially similar to the federal statute or rule. And they cite C. General Motors LLC versus Buchanan, 313 Georgia 811 pinpoint 821 to Charlie, where the language of a Georgia statute deviates from the federal rules of evidence or the persuasive value of the authority interpreting and applying the federal rule is diminished. And then they cite Stubbs versus Hull at 308 Georgia 354 pinpoint 358. In construing a Georgia statute that closely tracks federal statutory law, we may look to federal court decisions and commentary interpreting federal statutes or persuasive authority. I'm skipping a little bit, but it says the federal statute that contains language similar to OCGA 1611-131D which is part of the Gun Control Act of 1968, originally enacted, excluded from the following the felonies that disqualify convicted persons from acquiring or possessing.
Y'all heard it. I was watching it.
Federal or state offenses pertain to antitrust violations, unfair trade practices, restraints of trade, or other similar offenses relating to the regulation of business practices as the Secretary of the Treasury may regulate or designate. So I believe that is different than the matter that we have at hand. I'm also going to turn and talk a little bit about Massey, which is
Appreciate it, Brody.
Appeal to our Supreme Court to be argued in January of 2024 as designated and told to the court by Mr. Harvey and I think earlier Mr. Steele. In Massey, as argued by Mr. Harvey and others, are a couple things. What is the appropriate analytical framework for deciding Second Amendment claims? Does the crime of possession of a firearm by a first offender in Georgia have historical antecedent? Does the Second Amendment render appellant, in this case Massey's, prosecution for the crime of possession of a firearm by a first offender unconstitutional? So we have a distinguishing issue in our case is that we don't have this particular applicability of this particular first offender statute, and that we have the other portion as defined in 1611-131A. So let me make sure I get the right statute. A and as B, and B. It's a disjunctive statute, so it has several ways that that statute can be interpreted, and in this particular section, or who's been convicted of a felony by a court of this state or any other state. So that is a distinguishing factor in this particular matter that we have in hand. The issue that was raised by Mr. Harvey is, did the state build a record in the trial court as to why this law doesn't run afoul of the Second Amendment? And but distinguished Massey, unlike the circumstance we have in the case at bar, is that Massey's Second Amendment rights prohibit his prosecution for illegally possessing a firearm, particularly because he's not a convicted felon. So in this particular circumstance, that is different than in our case, because then it, as distinguished in the argument made by both counsel this morning, whether or not that is, you are then a law-abiding or responsible citizen as a Second Amendment application. And similarly, Mr. Harvey argues that the state has failed to provide proof and to meet his burden in persuasion. I believe the state's brief subsequently covers that particular historical and as well as the record in the trial court as to why this law doesn't run afoul of the Second Amendment. I'm also going to take, for the purposes of this particular argument, defendants 1 and defendants 2. Mr. Uhalski, do you have anything else you want to supplement, or do you wish to adopt Mr. Harvey's D1? As terms of development, of historical development.
I have nothing to offer, no opinion to share on that, Your Honor.
All right, because I'm offering you, do you have anything else to show that the historical development of the United States Second Amendment? It appears that Massey would require the state to do some particular historical development of the Second Amendment. I believe your brief does adequately address that. However, that's not evidence. That's just a pleading in this case. Mr. Harvey submitted evidence for this particular point. So if you want to adopt it, that's fine. I don't have any issue with it, but I'll accept it as evidence in this case as to the development of the Second Amendment, along with your brief.
Beg the court's indulgence for just a moment, Your Honor, if that's all right.
Are y'all not entertained? God damn it. I can't wait till the official trial start, man. I'm just like, lately the hearings, it been like 9 and 8 hours. Imagine trial. Like these people, man.
While you're thinking about that, I'm also looking at Massey, and it appears that Mr. Harvey's reliance or discussion about range and Bruin, the Bruin analysis would require some historical analysis, and it appears that the Eighth Circuit has relied upon the Supreme Court's assurances that gun restriction laws are still viable, and it conducted a fairly extensive required historical Bruin analysis, and that's
Your Honor, if I may, I'm going to ask the court, to the extent that Your Honor is asking us, do we adopt Mr. Harvey's exhibits as sort of the exclusive way of looking at the historical analysis that is, or would be required if you get past that first prong of Bruin?
Yes, that's one way to look at it.
So the answer to that is we don't say there's anything wrong with him putting that forward. If Your Honor is saying to us that the state is required to, rather than supply the historical analysis in the pleadings, Your Honor would prefer that we kind of physically put into evidence exhibits of sort of the historical analysis that we have put in our response. I would just want a clarification on that issue, because I don't want to rest here and then not have the historical evidence that the court would like to look at if it's not in the right format. Let's say, is the court requiring that we put into evidence these sort of statutes and these items of historical scholarship that we've referenced?
And looking at Massey, it would appear that that would be required to show there's an historical, because you have the burden of proof to prove that. It says the government, because
well, is it the burden of proof or persuasion? I mean, this is going to be from Bruin, and this is the United States Supreme Court. The question is whether historical precedent from before, during, and even after the founding evinces a comparable tradition of regulation, and it assigns the burden of showing the historical analog supporting the regulation. I'm not aware, and I do not understand that to mean that this is an evidentiary hearing wherein we would need to put in like sort of the physical, I guess, copies of the statutes and things like that. If the court is of the opinion that that's required, we're happy to provide that and supplement what was presented today with all those things. But I do understand the court.
That's my concern looking at Massey and looking at what the argument in Massey is at this point in time, is that, and that's why Mr. Harvey presented this particular evidence, because it would seem to me that that's what the Supreme Court's probably going to take up in our Supreme Court, as well as the others may take up to determine whether or not there is a constitutional framework in that respect. So that's why I'm saying that it might be helpful to include that in the record.
Would Your Honor permit us an opportunity to supplement the record as described here? And if the court's, I'm sure the court has looked over the.
Oh shit, I've been talking this whole time. I ain't know I had it on mute. Okay, I'm answering Paradox question. Paradox say, which way do you think this will go? And tell you the truth, it looked bad for Thug, but at the same time, when you kind of know the law a little bit and you see what's going on and you recognize what's going on, it's a lot of stuff that's working in Thug favor, right? But the problem is, it's a jury trial. And I said this before. We tend to pick a jury trial because we feel like we would get a fair opportunity to win the case, right? That's why we pick jury trials. But the thing with a jury trial is the jury don't know the law. So it's really based on if the state or the defense persuaded the jury you're innocent or not. It's not about the facts. It's about, was the jury persuaded that you're innocent or not, right? But if you go with just the judge deciding your faith, the judge know the law. So the judge may see something that the state said or, brought to his attention that's can prove you innocent, and the judge will find you innocent off technicality. You feel me? But like I said, we normally go with a jury trial because we feel like the jury has no connection to the law, so we feel like we have a better chance of being judged fair. But that's the perks, the pros and the cons when it comes to picking a jury trial. You know what I'm saying? So it looked like it's kind of going in Thug favor a little bit, and it still look ugly, but it all depends on the jury. So we never know. But if the judge was making the decision, I think he'll be found innocent. But this is a jury trial. So y'all got to think about that too when y'all in these situations. And it all depends on the vibe you get from the judge too. You know what I'm saying? If you feel like the judge ain't gonna judge you fairly, get a jury trial. You know what I'm saying? But if you feel like you got a pretty fair judge, take your chances with the judge because he know the law. He know the law. Judge could see and recognize shit and be like, nah, this bullshit. This person innocent. You know what I'm saying? Just off the law. But the jury don't know the law. They only going by if they feel you're innocent or guilty.
For the pleadings, I'm not going to belabor that. But if the court believes that it is required that we sort of submit these items of historical scholarship and historical and legal, we would ask for an opportunity to supplement the record. I can say that.
And I've been seeing a couple people saying that they don't think this judge is on Thug's side. Now, I'm not gonna lie. I don't know if y'all do y'all just expect this judge to be, just it's about Thug, just show favoritism. And I even seen it in the Melly case. I seen that people were saying that they don't think that Melly judge is a good judge that on his side. This judge right here has got on the state ass. He been on they ass heavy. So to me, I think he's a fair judge because he been on the state ass more. He been on Thug them lawyer ass. You feel me? Today is my first time really seeing him trying to take Thug lawyer head off. Now, what a YSL lawyer's head off. Now, when it first started, it was a lot of chaos. He was on their head. He was on the lawyer's head. Remember, he was finding them and making them buy lunch and all this stuff here. What he was doing there, he was setting the tone to bring authority to the courtroom to let them know, look, this is not a game. This is not a game. This is not a circus. And y'all gonna act the way y'all supposed to act. For some reason, at the beginning, if y'all don't remember, it was totally chaos. It was totally chaos. But when I look back at it, I think the judge was just demanding his respect and the order in the courtroom. He was trying to set the tone. It was a lot of stuff going on. It was a lot of foolery going on. You know what I'm saying? But I won't say that he's been, not good to Thug them because he been on the state ass. When they go on another break or something, I'm gonna play the clip where he was telling the state, y'all keep bringing all this new evidence, but y'all ain't showed us nothing. And if you don't present this shit by a certain date, that shit is getting threw out, man. Y'all got 200 some new witnesses. We haven't seen one. He been on their ass for real. If you been really on the case, he been on their ass for real.
For my part, it was not my understanding that sort of evidence in the form of actual statutes and these law review articles and these decisions that are provided in the pleadings would be necessary to decide the issue today, Your Honor. Would the court be amenable to that at this time?
Yes, but I don't have a lot of time because you're starting on on Monday. And if you're not, and I need to rule on it so you can present proper argument and presentation of evidence.
How much time would Your Honor be willing to give us to summon all this and provide it? I can tell you we'll do it at the court's pleasure. We'll do it in a hurry, Your Honor.
Yeah, and finishing the citation for Jackson, that's 69 F 4th 495 8th Circuit 2023. And in the Eighth Circuit, they concluded that in determining, the sufficiency of historical evidence to support the 922G1, we conclude the legislature's traditional employment status-based restriction to disqualify categories of persons from possessing firearms. Whether those actions are best characterized as restrictions on persons who deviated from the legal norms or persons who presented an unacceptable risk of dangerousness, Congress enacted with an historical tradition when enacted 922G1 and the prohibition of possession of firearms by felons. So, it seems to be Mr. Uhelski and Mr. Harvey, that looking at tandem of Massey and Kuhlman, that in order for this case to be properly reviewed on appeal, that you would probably need to have some evidence to support in the record to support historical analysis. It's listed in your brief, but as Mr. Harvey was quick to point out, he's the only person that's putting the evidence in at this point in time in the historical development. So, and I believe that, that can also include the statutory and case law development of this particular statute. So you may come up with the same conclusions he's come up with, and with the legislative history as to why we have 16, 11, 131, and 133. I believe your discussion adequately handles it, but there needs to be something that would be admissible or being put into the record. So I'll leave the record open until tomorrow. At noon for you all to submit something, and then I'll make a final ruling on that issue at that point.
And Judge, I understand what you have just requested in the additional time, but let me object to that. This has been on, this is the third time this case has been on for argument. I've made the same arguments over and over again. The state has simply failed to meet their burden. I think the case law is clear. I object to giving them a second bite at the apple. I think we are in a position for you to rule and or to sever those counts out and or give us a right for interlocutory appeal on those particular counts as well. So I'm going to object to additional time to allow the state to do what they should have done when we were here for hearings the last two times. So just want that on the record.
All right, so noted, sir. I'll take that over your objection, sir.
Okay, thank you, Your Honor.
All right.
Understood.
And I'm assuming I get time to respond?
Yes, Mr. Harvey. You certainly may. I will come with your arguments because I am going to rule at the conclusion of tomorrow. I mean, I'm basically ready to rule, I think, at this point in time, but I'll give the state, given the position of the cases that the court has read this morning, and because I want to get this right on appeal and preserve it for appeal correctly, the opportunity to do so. So if you have anything else, you can bring it on Friday, bring it on tomorrow, and we can hear it. Okay.
Well, I don't know what else I'm going to have because I don't know what the state is going to come up with, number one. I'm ready for the court to rule now because this was our opportunity and this is our record.
Understand that, sir.
All right.
Okay. All right. Thank you. All right.
Salute, bosses.
Okay, councils, I'm going to take up one other matter and then we're going to go lunch, okay?
It's bosses. Salute, bosses. I've been calling you bosses. Salute, buddy. What the fuck going on? Hey, but say, bro, I can't trust no lawyer that stuff. Yeah, they just finished picking the jury. They finna get ready to start trial in a minute. This right here is a hearing. But this will be the longest trial in history, they project. Yeah, they supposed to be trying them together. Some of them got took off the case. But yeah.
As a non-record aside, Judge, it is Mr. Box's birthday today, and it should be noted that he is wearing a pair of Sansa-belt slacks and tennis shoes.
And here it is, proof of the record. He said to do.
Happy birthday, Mr. Boss.
Thank you.
And many more. But if you're gonna wear tennis shoes, you need to upgrade your tennis shoe game.
Now, these are the stop.
I recommend you not see anything.
When I try, I wouldn't let me go.
Shit, what you mean all the defendants left? I know it's what it started out as 20 something, 28 or something. I forgot how many it was. I think it was 20 something. All of them have took a plea except for like 8 of them. All of them have took a plea, and some of them already been sentenced, pleaded out. Yeah, so I think it's only like 8 of them left. For real, for real. Yeah, it was 28 of them, and it's only like 8 of them left. Most of them took a plea. And some I think it was like 3 or 4 of them, probably 3 of them that was took off and gonna be tried separate. Say the people on the jury must all be retired then. Hey, I'm telling you, that's why one of the ladies that was supposed to be picked, she a teacher, and she was bucking their ass. She even called the fire marshal, say the courtroom's too packed so she could get out of jury duty. She said she a teacher, she can't miss all them days. Say she can't miss all them damn days, man. Yeah, the ones taking it to trial. I think it's like 8 of them left. The rest of them play it out.
All right. Good morning, juror, or good afternoon, juror 144. Could you come to the podium for me, please, madam? Okay, madam, you know why you're here?
Yes.
Okay, all right, just want to make sure. You were supposed to come in on the 1st of November to participate in our selection process. And we attempted to reach you by several means to include email and or phone calls from our jury services. Did you get those?
I got a phone call. I never got an email.
Okay, did you have any conversations with our jury services staff?
I did. I spoke with Amy.
Okay, all right. Did she tell you to come in for the 1st?
Well, when I spoke to her, it was on the 1st.
Did she talk with you prior to that? Are you sure you didn't have any discussions with anybody else prior to coming in on the 1st of November, telling you how important it was for you to be here on the 1st?
I'm sure.
So you did or you did not?
I'm sure I did not get any type of notification. I didn't speak to anyone directly about being here on November 1st. Until November 1st.
When on November 1st did you find out that you were supposed to be here?
Amy gave me a call.
So you didn't have any conversation. I'm going to ask you again. Did you have any conversations with jury services or anybody else pursuant to this case prior to November 1st telling you to come in?
Correct. That's correct.
All right. So you weren't, you fly for an airline, right?
I fly for American Airlines, yes.
So you weren't in Charlotte at that particular point in time?
At what particular time?
Before the 1st, let's see, on the 31st of October or the 3rd, which would have been a Tuesday, or the 30th of October?
At some point, yes, I was in Charlotte because that's where I'm based, yes.
Okay. And you didn't have any conversations with anybody about coming to Atlanta and about how you were at work?
Yes.
So you did have some conversation about you being at work?
About me being at work, yes.
Okay, all right. And why was it that you didn't appear on the 1st of November?
Well, the reason why I wasn't here on the 1st of November is because I wasn't sure that I needed to be here on the 1st of November until the 1st of November when I spoke with Amy and she was telling me that it was very important that I be here. So it wasn't clear to me until the 1st that I needed to be here on the 1st.
So you didn't have any conversations the day before about taking a standby flight or anything such as that to come here to Atlanta?
That was on the 1st. All that took place on the 1st.
You didn't have anything on the 30th or the 31st?
All of that took place on the 1st.
And when did you start having conversations with Ms. Von Kelch about that?
With who?
Ms. Von Kelch, Amy, our jury clerk.
Oh, I did speak with her on the 30th. I spoke with her on the 30th, as a matter of fact, and I told her that I was at work and if I needed to be here to let me know and that I would be here. And she said, I will let the judge know. But I basically let her know that, hey, I didn't get any notifications that I needed to be here on whatever day, because at this point, it wasn't clear to me that I needed to be here on November 1st. It wasn't clear to me. So when I text her, I gave her my position where I was and why I wasn't able to be here prior to the 1st. And if I needed to be here, to just let me know. And then I would be here. And then she replied and said, I will let the judge know. Thank you.
Okay, well, by the time that, ma'am, I believe that you're not being totally candid with the court about the conversations that you had with Ms. Von Kelch and prior to the 1st, because we started to contact people before then to come on the 1st, because we had to conduct the jury selection process at that point in time. How far is Charlotte from Atlanta?
It's 4 hours, 4 hours and some change.
4 hours of drive, 4 hour drive?
It's yes, sir. 4 hours and some change.
All right. Well, madam, I don't find your explanation as to why you weren't here acceptable. I'm going to hold you in willful contempt.
Well, can I say something else really quick?
Sure, you can say something else.
If you would understand my line of business, when I'm flying, I'm in and out of base. And when it comes down to the notifications, because I don't mind being here, it would be my honor to be here. I knew that it was coming, that I needed to be here. I honestly did not know that I needed to be here on the 1st. On the 30th, when I spoke with, I didn't speak to her, it was the text message. I was in Columbia.
Columbia, South Carolina?
I was in Columbia, South Carolina, because I had gotten off of work in Charlotte earlier that day. Now, when I get off, I don't automatically just come to Atlanta. I did not have no idea that I needed to be here until that night. And it was still unclear.
That night of the 30th?
The night of the 30th.
Okay.
And it was that night of the 30th. So at that point, it was no flights for me to get. I don't drive. Well, I don't have my own car, so I rely on that other type of transportation. So my family lives in Columbia. So when I'm off of work, I go ahead and I go to Columbia, or I'll fly here if there's a flight that'll get me here, because I'm standby. I don't have direct flights.
Yeah, I understand it.
So I am really honestly telling the truth. I did not know I needed to be here. However, when I did speak to her personally, when we were on the phone together on the 1st, I did everything in my power to get here. I booked flights, but the flights were red. There was no way I could have made it here in time to get here. I even had my 8-month pregnant niece say that she would bring me here. But by that time, she said, don't worry about it. We'll subpoena you so that you can be here. And I still came, but I was in communication. Once I knew that I needed to be here, I was definitely in communication. I wasn't hiding. I wasn't doing any of that.
Okay, well, why is it that on the 30th you decided, you came to the conclusion that we weren't going to need you on the 1st?
Because
or you didn't know whether that we would need you on the 1st.
It wasn't clear to me. It was not clear. It was not clear to me that I needed to be here until I spoke with Miss Amy on the 1st, and she told me the severity of me being here. And at that point, like I said, I did everything in my power to be here. I sent flights to let you guys know that, hey, these flights are red. There's no way that I can potentially make these flights. And even if I do make the flight, it'll be probably past the time because it was a connection. There's no direct flights here from Columbia. There are no direct flights here. I have to connect in Charlotte or Philly or somewhere to get here. So that's 2 segments that I have to get get here. And I even, like I said, I was trying to get a ride, and my 8-month pregnant niece said, she'll just take me.
You didn't
And
do that till the 1st of November, though, did you?
Sir?
You didn't try and get a ride till the 1st of November.
When I realized that I needed to be here, yes. On
Why
the
didn't
30th.
why didn't you think you need to be here prior to that? I mean, because we tell people we call you, you got to be here. So I just don't.
No one called me.
The court just does not believe that you could have come. You could have made your way here. You had 2 days to get here.
I did not have 2 days. The 30th is what
we contacted you on the 30th. So at least we made positive contact with you on the 30th. You'd agree with that, right?
Yes.
Okay. So how come you couldn't have just started making arrangements on the 30th to come here for the 1st?
But I did start making arrangements. I just told you there are no direct flights here from Columbia.
Why not drive?
Because I don't have a car.
Okay, and it wasn't until the 1st that you got your 8-month-old pregnant niece was.
Well, she was the only one that was available at the time because they have, jobs and all that and all of that. I honestly did not know the severity of it until the 1st.
Well, I think you know now the severity of it.
Oh yeah, and I did everything I could. And is Amy here?
She's has other duties at this point.
Okay. Well, I was speaking to her and calling her back to back to just make sure that, hey, I'm coming. I'm going to make it here. And I told her that day, I said, I'm not trying to hide. I'm not trying to do anything. I sent you the flights. I would love to be here.
What time are you supposed to be here on the 1st of the 1st of November?
No one ever told me a time.
So we just called you and told you need to be on the 1st. We didn't give you a time.
It was more like, you need to be here now. When can you be here? Like phone rang, you need to be here. And from that point on, I did everything. I started booking the flights, and I want to say it was around 11 a.m., 10 a.m. because I remember the first flight was around 12. And I still needed to get dressed and get a ride to the airport to get to the airport. And I communicated that with Miss Amy on the phone. And so I said, well, I'm not going to be able to make the 12. I will try to make the next one. Once I realized that I wasn't going to be able to make the flights because, first of all, they were red. I hadn't even been checked into them yet. That's when I said, okay, I need to go ahead and try to get a ride. And then my family was trying to help me at that point. Because 100%, that's when I realized that, hey, I need to be there. So, of course, I didn't want to get in trouble. They didn't want me to be in trouble. So, job or no job or whatever the case. I mean, I really tried. I really, really tried. And I still ended up coming. Although she told me not to, I still ended up coming. I was at work. I mean, I can show you my schedule.
Man, I feel like they got to do a better job with this jury selection shit, man, because I feel like by them making people come, that may change the outcome in the case. That may change people's look on things. Like, you got people that, is forced to come to do jury duty. What if they mad? What if they automatic find the person guilty? What if they automatic find the person innocent just because they mad that they had to come? It got to be a better solution to get people to, engage with jury duty. Like, I feel like it should be a situation where you get a group of people that volunteer to want to be on the jury. Not that specific case, but just saying, yes, I volunteer. If you ever need somebody to be on jury duty, I would be interested. And you have a group of people that volunteered, because people that, listen, if they pick me, I want them to pick me for jury duty. I don't care what a bitch did. If they pick me for jury duty, bitch, they innocent, because I don't want to be there. Goddamn it. I'm going to be the example to help change the law. You hear me? Pick me and I don't want to go. Goddamn it. Innocent, innocent, innocent. I don't care if they the worst criminal in the world. Innocent, bitch. Because I told y'all I ain't want to be here. So y'all need to change some shit up. Like, this is ridiculous. Like, this is ridiculous. This lady is 4 hours away You telling her, goddamn it, if you want her to beat her so bad, go get her, goddamn it. If you want me to come 4 hours away, come get me, motherfucker. I ain't finna spend my money and my time trying to figure out how to get somewhere that I don't want to be. If you want me to be there, come get me, goddamn it. That's what she supposed to been telling them motherfuckers. I'm not paying for no gas. I'm not paying for no Uber, and I'm not paying for no flight to spend my money to go somewhere I don't want to go. Who do that? Who do that? Judge, you come get me your motherfucking self, bald head fucker. Come get me. You want me to come? Come get me. Pick me up in your personal car. Or send me a motherfucking ride or a plane ticket.
I can show you the segments of flying. I can show you all of that, whatever you need to see. But I was at work. I was not somewhere just twiddling my fingers and just, screw the world. I was at work. I did not know. I did not know.
Madam, just stand fast a second, okay?
Sir?
Just stand fast a second, okay?
Mm-hmm.
Madam, you can have a seat in the gallery over there. Just have a seat just a second, okay?
Now shit, 4 hours, 3 hours, it don't matter. Them bitches still hours. She gotta pay for a ride or pay for a plane ticket. Man, I'm not doing that. I don't give a damn. That motherfucker listen, that motherfucker could have been 30 minutes away. If I don't have transportation, y'all need to find a way to come get me. It could be 10 minutes away. Come get me. If y'all want me there, come get me. I'm not finna spend my own money. That could be my last couple of dollars that I gotta pay for transportation to get to somewhere I don't want to go. Say on top of that, she missing money to get there. Be there, right? The motherfuckers don't pay. Only thing they do is feed you. I'll bring my own lunch. I don't need you motherfuckers to feed me. I'll bring my own lunch, goddammit. Compensate me for my time that I'm gonna miss at work if y'all want me to be there. Compensate me, goddammit. Because I need to make sure these passengers on this airplane is safe, sealed, and delivered to where they're trying to go. And that's my only concern at this point. I would have went in that bitch. I don't even like thug music. So off top, he gonna be guilty to me, Judge. So as you should, you want me to be here. Because I don't like the nigga no way. Or I go in that motherfucker, Judge, this is my favorite rapper. Now, if you expected me to choose fairly, it ain't gonna happen. Because I don't see no wrong that Thug could do in my eyes. Now, what is we gonna do? That's how I walk up in that motherfucker. Put me in contempt. And when I get out, I still don't see no wrong that Thug did. That's my favorite rapper in the world, Judge. Now, do you want me on jury duty? Because he innocent. I can tell you that I'll rip. I ain't even got to hear the evidence. I know he innocent. Shit.
Okay, you're 144. Come on back up, please.
They called me for jury duty one time. And I can't tell y'all what I told them motherfuckers over that phone. And they ain't never been picked for jury duty again.
Mm-hmm.
Says, hi, Amy. This is juror 144. Hope you're well and staying safe. I apologize for not being present for any scheduled appearances. I haven't received any notifications regarding it. I'm a flight attendant. I'm based in CLT, which is
Charlotte.
Correct? Okay. My last trip began on Sunday, the 10/29. I work again on 11/2. I will not be scheduling land this week. However, please let me know what the courts are requesting from me so I can coordinate with my airline. Do you recall sending that message?
Yes.
And I think that message, just want to make sure, was sent on the 31st. And do you remember Ms. Von Kell sending you back and that was sent, I think.
That was, yes, sir. That was Tuesday.
5:54 p.m.
Okay.
And then Ms. Von Kell, I believe, texted you back or sent you a message back. Good evening, thank you all for reaching out. I was advised to judge.
Yes, sir.
So around 5:54 on the 31st, you at least knew that you were supposed to come to Atlanta, correct?
At some point. Yes, sir.
On the 1st.
No one said anything about the first, sir. If I did not know anything about the first until the first, honestly. That's why I said, let me know what the courts need for me to do so I could be there. That's why I said that. Exactly why I said that. I didn't know anything about the first. As a matter of fact, I got a notification at my house on the 31st that was delivered to my house on the 31st that I received. One of my tenants sent it to me on the 31st. And to my understanding, I needed to be in court on the 31st, which was that Tuesday. So because I know that I was at work and I got off earlier that morning or that afternoon, I'm now under the impression that, okay, I'm going to be rescheduled because I missed the 31st. I didn't know about the first until the first, all honesty.
Now, I don't believe it based on what I have. But what I have,
But how not?
everybody else appeared when they should appear.
I would have loved to be here though. Like, I did not know I needed to be here.
I've given you the time to explain. I'm going to hold you over contempt. Here's your choice.
Yes, sir.
Your choice is, it's either contempt is punishable by a fine of $1,000 and or up to 20 days. Okay. We value this procedures is that important because selecting a jury ensures that both sides get a fair trial, a just trial, and a lawful trial. I had to literally try and find you because I'm required to account for every single juror that we had to examine at that point in time without fail. So we're waiting here trying to figure out where you are, and this is the only thing I have. Now, I understand you got to work and everything else, but I believe that you had enough time and enough knowledge that you could have gotten here in the first. That's what I have. That's where we disagree. I think that you knew that we were trying to contact you the first. You need to be here. So what I'm going to do is 5 days in jail, or you can come between the 4th and the 8th of December and sit here and listen to the case as presented on those days.
I'll be here.
Your choice.
I'll be here.
All right, so we will contact you. You need to be here on the 5th. You need to stay here the entire part of, on the 4th. That will be a Monday. Check my calendar. It's the 4th. Find your place. We'll find you a place where you can observe the proceedings, and you'll be required to check in on a daily basis. And then after Friday's proceedings are complete, then your contempt will be satisfied. If you do not appear, then I reserve the right to you'll spend the rest of the time in custody. Okay.
Yes, sir.
Right. Okay. So that's how important that we consider these proceedings. So, and that will satisfy your contempt in terms of just coming here and watching the proceedings and being aware of what we asked you to participate in, how important that is. Okay.
Yes, sir.
Okay. All right. You have any other questions?
I do.
Yes, ma'am. What's your question?
So this week, I was supposed to be at work on Monday through Thursday. However, I got a phone call from Lieutenant Gibson saying that I needed to be home because I needed to serve the papers so I could be here today. I'm asking the court if the court could give me some sort of an excuse or some sort of notification to let my job know why I was not at work on Monday and yesterday. I understand about today. The paper only said today. So
Why are you asking me to give you something for the last 2 days?
because I needed to be at work on Monday. However, the fear of God was placed in my heart on Monday to be home. And if I'm not home, it's not going to be good for me if I'm not home. So therefore, I stayed my behind at home.
Well, you just need to be here for the first. For today, that's the 15th.
I understand that.
So why is my involvement necessary for the 13th and the 14th?
Because if I wasn't at home on Monday, I would have never got the notification or to sign that paper. I needed to be there physically. I needed to sign it. So in order for me, yes, sir.
So you got the notice on the 13th. If you were personally served on the 13th.
On Monday, yes, sir. And I needed to be home to sign it. But I needed to be at work too. So I couldn't go to work because I needed to be home because I understand the severity of this situation. So I was not home. I was not going to work. So because of the way that flying works, I'm not able to go to work, fly a couple flights, and then just come back home. Like when I'm gone, I'm gone. There is no coming back home. So therefore, I had to stay home on Monday to get the paperwork in order for me to be here today. And I had to stay home on yesterday because I needed to be here in place for this morning. Yes, sir, I do.
Show cause at the bottom has November the 13th and it has your signature on it.
Right.
I would think that would be sufficient.
No, because it only, that black and white up at the top, it only says that Mary Frances Green needs to appear in court on Wednesday, November 15th. So my job is like, okay, so what happened to you on Monday? Why wasn't you here on Tuesday?
But, the 13th, you stayed home to receive service.
Correct.
Well, what's the excuse for the 14th? What's the explanation I can give for the 14th?
The explanation that you can give them on the 14th is just jury. I needed to be home so that I can be in place for today. Because again, there was no way that I could have made it to work yesterday and come back to Atlanta in time to be here in position this morning at 9:30 when I needed to be here.
That's an explanation that, if you have to give your employer.
I told them.
Okay, and what's their response?
They took off today and tomorrow because there's nothing on that paper that says the 13th and the 14th. I'm the middle person here. I have to answer to you and your office, and I have to answer to them. And on that paper, the FAA, all they see is that flight attendant was a no-show, which is another fine that I have to do.
Well, I believe the notice, the amended order shows that you signed for it on the 13th.
Yes, sir.
So, I can see that. The 14th is a travel day for you. But I won't have any knowledge of that. And the 15th, you're here for show cause.
The whole purpose of me not being at work this week is because I needed to be here today. All 4 days. The whole purpose of me missing 4 days of work is because I needed to be here. Well, I have time now. I have time because I'm assuming your administration is going to give me some sort of paperwork to let them know I need to be there that week. Yes, sir. So that's that. Yes, sir. So that's that.
Okay, 0144, here's what I'm going to do.
Yes, sir.
In the order satisfying your contempt, I'm going to state that you received your notice on the 13th. 14th was a travel day. You're actually here on the 15th. And then I'm requiring you to come back, satisfy your contempt. 4 through 8 by observing these proceedings. And then you'll be satisfied. So that will recall those dates. Is that acceptable?
Yes, sir. Thank you.
We'll have an order to that extent. And we can send that to your email. Probably be done sometime today to normal morning release. Is that acceptable?
Am I not able to get it while I'm here?
No.
Okay. Yes, I'm so sorry.
No.
Yeah.
Not right now.
Yes, sir.
I just don't have the ability to do that right now, but I believe that You should get it by the end of business today or possibly no later than tomorrow. I can say that Mr. Turns, my staff attorney, will endeavor to get that out and filed, so you can get an official copy with a ribbon on the top of it saying that Kane was actually filed in this case, okay?
Yes, sir.
You have any other questions for me? This is the courtroom you need to be in, okay?
Yes, sir.
And we'll find, or you report it here, and then we'll tell you where you need to be. You'll either be in here or you'll be in 8H, okay?
I do have a statement. If I don't have a question, I have a statement, if that's fine. I just wanted to say that I sincerely apologize about the miscommunication here that took place on everything. I would have loved to have been here. I just did not know. And I do apologize that you and I disagree on that portion of me knowing that I needed to be here. However, what I'm telling you today is the honest truth.
And your apologies.
Thank you.
I'm going to include, for the purpose of the record, the amendment order to show cause and the correspondence with our jury with Ms. Fine Kelsey in these two court proceedings. Madam, unless you have anything else, we'll see you on the 4th of December for 9 o'clock, okay?
9 a.m.
Yes, ma'am. All right.
1C. Thank you.
Yes, ma'am.
All right.
See you then, okay?
Yes, sir.
All right. All right, council, we're going to take a brief rest for lunch. We'll come back at 2:45. And see you all at that time.
How y'all feeling, man? How y'all feeling? Is wrong how he did it, or she came out all right? Is wrong how he did it, or she came out all right? Let me go back to the. They're on recess right now. Hold on. Let me go back to the lyrics.
For a proper purpose. I know that Mr. Steele argued very eloquently yesterday about it being character or improper character, propensity. It's not being admitted for improper characters that would fall under the court would certainly screen it under certain other evidence standards. And the propensity argument that was made yesterday, this, as mentioned by the state, this evidence is not being admitted saying that Mr. Williams and any others did these things before, so they do them again. So I'm dissuaded as to the propensity argument. As it pertains to the issue of mental state, argued under 27-7-404B, expert witnesses, if qualified, may draw conclusions about intent as long as they don't state that this is the defendant's intent. So to Mr. Matthews and your continued argument about that, and Mr. Steele as well, as long as those experts do not cross that particular line, those particular things would be relevant. I've also considered United States versus Smith at 918 F3rd 825 that assuming a foundation can be laid, certainly, and if it's within this can of expert testimony, that certain terms or technology or terms and or symbols or signs may be appropriate and relevant, giving meaning to gang determination. And then, so for those particular reasons set forth therein, the court is going to admit for the limited purpose thus far, the state's request to apply the evidence statute as written. I'm going to conditionally admit particularized lyrics, and those lyrics are found within states 18. There's 17 sets of lyrics. They're from pages 1 through, I should say 41 through 49 of states 18, 41 through 41 through 49 of states 18, submitted for the court's consideration yesterday. Those specific statements, the court will admit, I'll conditionally admit those pending lyrics, depending upon or subject to a foundation that is properly laid by the state or the proponent that seeks to admit that evidence. And to that extent, I have also considered the Taylor, White, Torres, and the Commonwealth versus Knox cases, and I find this to be that the conditional admission of these particular lyrics are proper. I would just ask the state, or just remind the state, if any other lyrics are sought to be admitted, that I'd have to go through this same analysis. And if you would do so prior to us putting a jury in the box, that would certainly be helpful.
They're on recess again. Give me a minute. Give me a minute. Find something for her. So we know that he agreed to allow some songs be submitted as evidence and to be presented in the case. It was something else. Oh yeah, I want to show y'all how he was getting on the state ad. Let's see what this is. Y'all make sure y'all hit that like button if you haven't. I'm gonna play this one till I can find when he would get on the stage.
Did you just sign that indictment?
Yes.
Okay, this right here is one of the last co-defendants to switch his mind and go with a plea deal. You know what I'm saying? At first, He went viral for him and another defendant. They were saying they weren't taking no plea deal. They gonna thug it out. But all of a sudden, he had a change of heart. After a couple of months and thinking about, man, I might be in that bit for 60 years, 40 years. He say, look, I might as well just go ahead and go the easy route, gang. And that he did.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
How old are you?
23.
And how far did you go in school?
I went far.
What's that mean?
Like 12th.
You went to 12th grade?
Mm-hmm.
Did you graduate?
Mm-hmm.
Is that a yes?
I mean, yes.
Okay. Are you able to read?
That nigga
write,
lying,
and
man.
understand the English language?
Yes.
With respect to indictment 22 SC 183572, how do you plead to conspiracy to violate the Racketeer Influence and Corrupt Organization Act? Guilty or not guilty?
Airbnb paid me $3,000 today without even needing to own or lease any property myself because we collect rent.
How do you plead to theft by receiving stolen property? Guilty or not guilty? How do you plead to violation of the Georgia Controlled Substance Act in count 9? Guilty or not guilty? How do you plead to violation of the Georgia Controlled Substance Act as to count 10? Guilty or not guilty? How do you plead to possession of a firearm by a convicted felon? How do you plead to participation in criminal street gang activity? How do you plead to armed robbery reduced to robbery by force? How do you plead to hijacking a motor vehicle in the first degree? Is this guilty plea freely and voluntarily given with a full knowledge of the charges against you? Do you understand that you have only a limited right to appeal this guilty plea conviction? Do you understand that you have only 4 years from today's date for the felony charges to file a habeas corpus petition challenging the voluntariness of this guilty plea? Your Honor, had this case proceeded to trial, the state of Georgia would have proved beyond a reasonable doubt that in late 2012, within the Cleveland Avenue area of Atlanta, Georgia, that YSL, who claimed affiliation with the National Blood Gang, was formed. The founders of that organization were Jeffrey Williams, also known as Young Thug, also known as Slime, Walter Murphy, also known as DK, and Trontavia Stevens, also known as Tick or Slug. That this organization uses a number of different identifiers, including colors, clothing, tattoos, and hand signs in order to show affiliation with that organization. That this organization is part of the enterprise, which is Young Slime Life, and that this defendant was a member of this enterprise and conspired to and associate together with others for the common purposes of illegally obtaining money and property through a pattern of racketeering activity and conducting and participating in the enterprise through a pattern of racketeering activity. In furtherance of the conspiracy, he engaged in a number of different crimes. Specifically, Your Honor, 2 of those crimes in racketeering activity, first being one occurring on May 8th, 2012 at 151 Cleveland Avenue, which is in Southwest Atlanta, Georgia, 30315, which is an Exxon gas station in what is known to be the Young Slime Life gang territory. That Mr. BB was a part of an undercover sting operation at the gas station. Officer Applewhite, APPLEWHAITE, was operating in an undercover capacity. He went inside of the gas station and encountered the defendant. Officer Applewhite asked to purchase marijuana. The defendant asked how much marijuana. Officer Applewhite advised he wanted $20 worth. The defendant then went into the area of the store, weighed up the marijuana, and gave that marijuana to Officer Applewhite. Once the sale was completed, other officers came in and placed Mr. Beebe under arrest. When they placed him under arrest, he was found with marijuana on his person as well as a gun. The gun was then ran and it came back stolen out of East Point Police Department from a car break-in in August of 2019. Additionally, Your Honor, about a year and 6 months later, in October 12th of 2021, this defendant, along with co-conspirator Christian Eppinger, were at 47 Cleveland Avenue, Southwest Atlanta, Georgia, which is also in the Young Slum Life gang territory. While there, the victim, Mr. Darius Smith, was at that location, which is a park next to a library. Mr. Smith was speaking with a friend of his, and while speaking with that friend, there were two black males described. One had a blue and black ski mask with a black and silver handgun. The other suspect had a black ski mask with a black handgun. They approached Mr. Smith and stated to him, "Give up that chain." Mr. Smith had a large chain that was very identifiable. That chain was a diamond encrusted chain that looked like a house. It said Trap Commander on it. They also took additional jewelry and other items from Mr. Smith, to include earrings, a diamond and gold necklace, 2 iPhones, his car keys. They then went and jumped inside of his vehicle, which was a 2003 GMC Savannah. They then fled the location after robbing him. Again, both of the individuals had guns. Mr. Smith initially called 911. He had left the location. A friend was able to take him to his brother's house, which was in Clayton County. When he called 911 in Clayton County, they advised he had to come back to the city of Atlanta. He did come back to the city of Atlanta and was able to encounter police, where he reported what happened to him a few hours earlier. During his time in explaining to the police what happened, he gave a description of one of the defendants. He said that he knew or was familiar with one of the defendants from the neighborhood. Although he had a ski mask on, he noticed 2 things: his eyes as well as his hands, and that he was missing a finger. After that, Mr. Smith was able to provide to law enforcement officers social media pages of first Durante Beebe wearing his chain and identifying him as the person with the missing finger that had robbed him. Mr. Beebe was on social media promoting the chain, having the chain, some would say flossing the chain in front of the camera, which was the chain that was stolen from him. Further investigation into social media, the officers were able to identify the co-defendant, Christian Eppinger, as the other person who robbed him. Officers were also able to get the social media information from Instagram, and they actually found on Instagram a recording of Christian Eppinger bragging about robbing Darius Smith that was turned over in discovery. After arrest warrants were taken out, Mr. Beebe was arrested, interesting enough, back at that same location in November of 2021 at the same 47 Cleveland Avenue, where he was arrested, arrested on these charges. And then Christian Eppinger was arrested subsequently on these charges in February of 2022 after he shot Officer David Rogers. Additionally, Your Honor, we have social media postings of Mr. Beebe and Mr. Eppinger that are a part of our overt acts in this indictment, which shows them being part of and associated with the conspiracy. Mr. Beebe in Act 143 of count 1 of our indictment is posting a picture along with co-conspirator Christian Eppinger wearing what we call an OTS sweatshirt, which is only the slime sweatshirt and sweatpants, again showing his association with the enterprise and the fact that he's acting in furtherance of this enterprise and to promote this enterprise, Your Honor. This is some of the evidence that the state would intend to show if this case were to move forward with trial, Your Honor.
Mr. Beebe, good afternoon, sir. Sir, did you have the opportunity to fully discuss the facts and circumstances of this case and the matters in indictment 21 SC 177912 and 23 CP 218502 with your attorney, Mr. Partridge, to your satisfaction?
Yes, sir.
And do you have any questions about any of the rights that you give up by entering a guilty plea in this case? Those rights were set forth on the record by Ms. Simone Hilton from the District Attorney's Office. Do you have any questions about those rights you wish to ask me?
No, sir.
Do you give this plea, did you have a chance to also read and sign the indictment that I'm holding up here?
Yes, sir.
Okay, do you have any questions about the indictment as it pertains to you in counts 1, 8, 9, 10, 11, 12, 27, or 28 you want to ask me?
No, sir.
All right, I don't know if the indictment's been signed and the plea has been entered. Mr. Beebe, based upon the responses that you've given during the court's inquiry, I'm going to find that your guilty plea is freely and voluntarily entered. I find a factual basis for your plea, and I'm going to accept your plea as tendered and as negotiated. So as to count 1, conspiracy to violate the Racketeering, Influence, and Corrupt Organizations Act, this court will sentence you in accordance with your negotiated plea to 10 years to serve 5 years with the balance probated. As to count 8, theft by receiving stolen property felony, this court will sentence you in accordance with the negotiated plea to 2 years commuted time served concurrent with count 1. As it pertains to count 9, violation of the Georgia.
Here's one thing you need to do before buying anything online. Don't spend another dime on Amazon.
We're not going for that. But what I heard Ms. Love say is there are I believe three statements. One of them is not Mr. Williams' statement, but regardless, they could play it, the body camera.
Well, that'll be for the jury to decide.
No, it's not. Unless Cedric Jones, who's not on the state's witness list, comes in and testifies, that is an out-of-court statement. That is an out-of-court statement.
It will be subject to an objection.
Exactly. It doesn't come in. I'm objecting.
Okay, but wouldn't that be when they lay the foundation, and if they can lay it in order for me to, wouldn't that be objectionable at that point in time?
Your Honor, I have a Jackson, for purposes of ease for my brain, I have a Jackson versus Deno, D-E-N-N-O, motion before you. I just want to be heard. It's not my burden. The burden now shifts to the state. They have to either do something. They have to do something, but I'm not agreeing. Everything was suppressed. Judge Adams suppressed the stop. He suppressed the statements. If you look at that transcript, and I could give you the exact page, he ridiculed, he wanted Brookhaven Police Department officers in the courtroom, and he stood up from the bench and he pointed his gavel at them, and he told them, you got to do better. You don't Mirandize people. It's in that transcript. I'm going by my memory, but I'll find it for you. It's at the end. I got reversed. Court of Appeals reversed. I lived with it. I asked for cert. One justice on the Supreme Court of Georgia said grant cert. The other, I think there were 7 at the time. Maybe there were 9. I think there may have been 9. They said no. So I lived with it. I never asked for it to relitigate that. I asked for any and all statements made by Mr. Williams to come under the auspices of Judge Adams' ruling, the Court of Appeals ruling in footnote 3, and the state of Georgia and DeKalb County concession. Ms. Love is saying we're not agreeing that it was conceded to. She has 2 or 3 statements. So I don't know what we did. I'm not trying to insult him, but I just don't understand what we did for 30 minutes hearing Ms. Love read the transcript. I'm just available for this court. And if the state wants to admit those statements, then you're going to have to rule on that before the statements come in, because that's your charge. I'm saying the statements don't come in.
I understand, sir. I understand. Okay, anything else? For now?
I think I said everything I needed to say.
Okay, thank you, sir.
And you know, to Ms. Love, I'm not trying to attack you. If you take a step back and objectively look, maybe you would hear what I hear the court saying. Thank you, sir.
Your Honor, I want to make it clear to the court that I in no way feel as if I am being attacked. I feel as if I am in a bizarre kind of circumstance where I'm accused of misrepresenting facts. And counsel for Mr. Williams read into the record exactly the things that I said. I am in a different kind of world when I am before a court who is being asked to admonish a party for making valid objections. And that is a different circumstance that I find myself in. Nevertheless, Your Honor, just to be certain that I did hear correctly, I believe that I heard Mr. Steele state that he is not attempting to suppress the items that were recovered from the stop. And I want to make certain that I did hear that correctly.
Yeah, that's different from the statement. So, Mr. Steele, are you still trying to seek that those things that were subject to the stop or found from the stop or flow from the stop as they're contained within states 7 and 8 in particular? Are you seeking to suppress those, or are you seeking to exclude those? I mean, they're subject also, of course, to a foundation that would have to be laid. But is your intent for the that's what I think State's Counsel is asking.
I never ever put anything like that in writing.
Okay, and I didn't think you did either.
Okay, all right. And the second issue is, I believe that Mr. Steele stated that his motion was in fact a request for a Jackson Deno hearing. And I'm reading it and I don't see any reference to that, but I do see reference in Mr. Steele's motion in limine number 4 to preclude relitigation of an ultimate fact issue that was determined by a valid and final judgment. And so in as much as the contentions being made in motion in limine number 4 are factually inaccurate, we would respectfully request that the court, in reviewing the transcript of the hearing, the statements made by the prosecutor, as well as the opinion issued by the Court of Appeals, deny Mr. Williams' motion in limine number 4.
Yeah, I mean, basically, Mr. Steele he's filed a motion to basically, and in motion to suppress number 8 and motion limiting number 4, if I understand this correctly, and I believe I do, he's just saying, hey, look, I want these things, I want any mention of them, but I'm going to honor what Judge Adams ruled upon, what the Court of Appeals ruled already. So he's just asking, he's telling the court, I need to make a decision. So if I adopt Judge Adams' rulings, which I would be required to, given that there's an appellate opinion on this particular issue, then...
Her ruling, Your Honor, because she did not...
No, his ruling.
I'm sorry, I do keep saying that. I'm thinking about Judge Adams here, and my apologies to the court.
Mustache kind of bald, kind of like...
My apologies, Your Honor.
Yeah, that's him. Yeah.
If the court is considering Judge Adams' ruling, Your Honor, the ruling as found by the Court of Appeals did not reach the issue of the statements that were made prior to Miranda. And they certainly don't touch on the statements that the state explicitly said, we are not conceding that these statements are inadmissible. The trial court, the Honorable Judge Adams, specifically referenced the statements that the prosecutor conceded that the state would not attempt to enter into evidence.
I think that's footnote 3, if I'm not mistaken, in the appellate opinion.
Correct, Your Honor. The ones...
Footnote 3, if I'm reading it correctly, would indicate that
the statements that the prosecutor conceded were not being touched upon because the prosecutor, as it relates to certain specific